2 on implementation and enforcement. Who has what kind of obligations? Who does what to whom? The fact that something is the product of a collaboration and negotiation, does that make a practical difference as to how agencies may or may not use it, or a court may or may not review it? And so with that, we'll start in. Errol is going to start. About half an hour.
Okay. Thanks very much. I'm very pleased to be here. I've read a lot of what people here have written or said. I think along with Rena, I'm sort of if not a skunk in the room, an outlier. I've been working for the last number of years on transnational collaborative governance, or new governance, I suppose. I'm thought of as a sort of a new governance kind of person. Now, let's see if I can manage this thing. All right, so I'm going to, and I guess I have to turn around so I can see my slides. I'm used to having my laptop. So I'm going to work from a thesis here, which is that regulatory requirements are increasingly being set outside governments, not such a big surprise, by competing programs, maybe something of a surprise, in sector-centered transnational networks by leveraging market chains. And I've, in the last few years, been writing about that kind of policy making. I think Phil, he said, well, hey, why don't you say something? I guess maybe he was thinking, why don't you say something about it, implementation and enforcement, so I'm going to try to do that. I call this, my own term, competitive supergovernmental regulation. I'll explain that. Now, if I can get this thing to move, what do I do? I'm having that same problem. The circle thing on the side is what I'm pressing. You want to press? Maybe I'm pressing something wrong. It goes back. Okay, to that machine. All right. So let me see if I can do that. Okay. But I missed thesis 2, I guess. The reason I'm doing this is I think we don't understand or even comprehend many aspects of what I'm trying to talk about, partly because we have blinders, bureaucratic ways of thinking about regulation in terms of hierarchy and mission. I think those blinders are particularly strong in this city, where we're sitting next to or in the shadow of a great regulatory behemoth, and because we haven't done a lot of research, either empirical or conceptual, on it. So for something a little different. All right. Now, so 2 things. I'm going to talk a little bit about what the heck I mean by competitive supergovernmental regulation. I'm going to give you an example, the Forest Stewardship Council. Let me ask, how many of you know about the Forest Stewardship Council? Okay, what I feared, the reason I decided I had to go through this example. So I'm going to give an example, talk about main features, and then in the end talk a little bit about some key issues I see, but I may not spend much time on them now. I'll write more about them in the article. All right, so what is forest certification? Well, it's kind of regulation. An independent expert assesses a forest management operation to figure out if it's managed according to proper standards and certifies it for actually a lot of possible recipients, consumers, trading partners, the broader public, governments. The forest certification is kind of like an inspection for compliance with regulatory requirements. Institutionally, it looks a whole lot like government regulation. There's a process of rulemaking in which standards are set. There's an adjudicatory process in which there's a certification of compliance or non-compliance. There are various accreditation processors for who can be a certifier, which I've written about elsewhere. And there are sanctions, including withdrawal of certification, promotion of certified products, and so on. I'll talk more about them in a second. Now, I just want to give you a very simple feel of what these standards are, and here are just a couple of them. Indigenous peoples' rights, the rights of indigenous peoples to own, use, and manage lands, territories, etc., shall be recognized and respected. A biodiversity requirement. And my point here is mainly to show you how much they look like regulatory requirements that an agency would write if there were an agency that had this sweep. And then these get turned down, these get focused in terms of criteria, which are more specific, and so on and so forth. Again, not for the substance, but just so you get a sense of the sort of style of it. Let's see if I can click it only once. I'll skip this one. So I'm talking here about implementation and enforcement. Those are fairly strict standards. They involve certification audits. They cost money. You might lose your certification. Why would anybody join? Why would any firm voluntarily subject itself to these requirements? And I have to say I missed one slide that talked about voluntary stuff, but we'll live with that. Well, you might come to your new headquarters in Atlanta and find these fellows hanging from the boom above your new building with your Home Depot logo, Rainforest Action Network telling you to stop selling old growth. You might find the press there, and so on. God, you might find these guys outside your Home Depot store in Toronto with their giant inflatable chainsaw welcoming you as they welcome me, saying, thanks for coming to Home Depot. We appreciate your helping us destroy the world's rainforests. Have a nice day. And then, of course, going on to explain why Home Depot could do a little better than that. You might bring your kids out on a Saturday morning associating Home Depot's name with the extinction of the coho salmon. And so on. It's good recreational activity. You might go to the Home Depot store in Vancouver and reclaim, with a couple of First Nations young people, and reclaim stolen cedar and invite Home Depot to arrest you and invite the media. So what's going on here? The claim is being made that Home Depot's commercial practices fail to meet required social standards. And this is a confident claim that's being made. Now, I don't know how many of you know the Home Depot story, but basically after about 700 of these events, Home Depot, which had been very skeptical of forest certification, suddenly found itself a supporter. And you can now buy a lot of Home Depot product. You can buy a lot of Forest Stewardship Council certified products at Home Depot. What happened next, to really shorten this story, what do you think happened when the Rainforest Action Network and environmental ethics turned their attention to Lowe's? 2 telephone calls. So, and these things, these are transnational movements. B&Q in Britain moved a little more quickly. OBI in Germany moved very quickly. So you have the imposition of environmental regulatory requirements, or the acceptance, based on assertions of duties outside the conventional legal system. So now what happened then? Well, industry, which had initially been quite confident that the Forest Stewardship Council would never take off, said, we better do something about this. And they founded their own programs, industry and landowner-driven, somewhat weaker and narrower, based on ISO kinds of environmental management system models, which I assume many of you are more familiar with, which involve a lot more intra-firm policy making and the requirement of programs and continuous improvement. Tend to be nationally based, but they were coordinated. Eventually, they were federated in something called the PEFC, which used to be the Pan-European Forest Certification Council and is now the Program for the Endorsement of Forest Certification. It's a global program. So what? Well, my argument is that this is a big part of what's going on in governance, in regulatory governance in the world, that it is increasingly where regulatory standards are being formulated. And to put it sort of, to overstate it, places like Washington are becoming the retailers of standards that are being produced elsewhere. So now, what do we want to, what to think about that? Here's just an example of an industry standard. I won't go through it. It's basically more of a, you got to have a program. This is the Sustainable Forestry Initiative, which is headquartered here. and is the U.S. industry response to the FSC, which is the global program that I was telling you about. SFI is part of the global constellation called the PEFC. Now, what I do want to note is that although the industry programs, which sprang up about 12, 13 years ago, were initially very weak and arguably in many cases aimed at creating confusion and undermining the FSC, have over time become much more serious and significant. It has not been possible to have a totally baloney kind of program. So I'm not going to spend a lot of time on this here, but what's being created is a competitive system of standard setting and implementation in these in this larger forum. And we could think of it as the emergence of what I call here a tournament of mutually adjusting programs, which eventually, I'm just going to, of course, it's not just the programs. It's the programs nested among governments, transnational NGOs, and transnational corporations, so that I would heuristically suggest to you that the modern forestry policymaking arena looks like this, where you have two essentially super-governmental organizations battling it out about policy and also implementation at the core of the policymaking system. And you have governments, corporations, et cetera, sort of on the periphery, but involved. Now, okay, I'm always tempted to go on digressions here, like what kinds of circumstances will this happen and what kinds won't, but I won't do that right now. The other thing that's important to say is that this kind of a thing is happening in many sectors, not all by any means, but many. So now here's a chart. It's again for heuristic purposes. This is a chart by Ken Abbott, who you may know used to be at Northwestern, recently at Arizona State, and Duncan Sneidel, who's at Chicago. They've been trying to categorize the individual programs in their so-called governance triangle. And these are all the initials of many of the different programs that exist in many of the different sectors. And there are many, many more of them. Sector 6, for example, and Sector 4 would be totally full. Basically, they're just trying to say, okay, where's the primary center of gravity? And so, for example, the FSC that I was telling you about is in Sector 6. SFI, that is, it's sort of halfway between firms and NGOs. SFI, which is the American one, is in Sector 2. I guess this is by way of lending weight to my argument that this is a very significant kind of development. The slide that was missed suggests that the transnational part of it is very important and that collaboration is going to be different in the transnational sector because we have no equivalent of Washington in the transnational sector. So in the Westphalian system, we have these somewhat chaotic set of states working with each other. So what do I think? When I say competitive supergovernmental regulation, what do I mean? I'm going to briefly talk about 6 attributes that these different programs tend to have, and I'm going to go sort of quickly. I'm going to focus then eventually on supply chain. Well, first let me say them. Supergovernmentality, by which I mean governments are involved, but they're much bigger than governments. Supply chain structure and leveraging is a key element, institutional mimicry, elaborate participation and transparency mechanisms, regulatory competition, and what I call imbrication with states, which I'm just going to elaborate a little bit more on what this collaboration looks like. Supergovernmentality I've already sort of outlined. Non-state actors are the primary standard setters, adjudicators, and enforcers in these systems. The non-state actors are business associations and NGOs. NGOs are usually the prime movers. The typical model is the one I gave you where an NGO program is created and then there's a countering one established by businesses, but it's more complex than that. Governments are present, but they play minor roles. Supply chain leveraging, I showed you a little of that. Why did the FSC take off? because Home Depot decided to prefer FSC-certified products in its purchasing practices. And so, I mean, if I put it overly simply, what happens here is rather than leveraging the sovereign power of the state, one leverages the sovereign or the market power of certain key actors. And I'm going to later ask, well, why does it spread? And so Home Depot, De Beers, Nike, whatever you want to talk about, these are the examples of points of great leverage. I'm going to say almost nothing here because I've written a lot about this. There's a lot of institutional mimicry, meaning that these organizations borrow many of their methods from, for example, the International Organization for Standardization or the Environmental Protection Agency. In other words, a lot of these processes look just like regular administrative processes, except freed from, for the most part, nuisances like judicial review. They have increasingly elaborate participation and transparency requirements. They use multi-stakeholder structures, very comparable to regnegs. They use notice and comment procedures of various kinds. They feel compelled to publicly explain their decisions. They are increasingly legalized and formalized in terms of roles and processes. So this is the global administrative law thesis. In other words, they look like other regulatory agencies. Now, regulatory competition. One way that they don't look like other regulatory agencies is that they don't have a monopoly on sovereign regulatory power. And so the question is, what are we to think of that? What does that mean? In most of these sectors, the NGO and industry-sponsored ones both compete, which I've suggested, but they're also mutually dependent. In other words, although let's say in the FSC example, the SFI was originally designed with the hope of killing the FSC, making it irrelevant, confusing consumers, etc. Let me imagine that that's what happened. Nobody's ever admitted that to me, but let me imagine that that's what happened. Well, what actually happened, as I said, the SFI became real. It became an actual regulatory program. And I once had so why do we have a couple of them around, and why do they both thrive rather than one losing out to the other? I don't have a good answer to that, but I have a fun little story. I once asked an industry lawyer about that, who's very familiar with this, and she said to me, well, you know, it's like the old story of the small town that was too small to support one lawyer, but could easily support two. Now, that's cheap in a way that's much more complicated than that, but you can see how the creation of a legalizing regulatory system may generate more activity in its own right in a sort of amplifying self-generating sort of way. They adjust to each other. They compete with each other. By and large, as I've suggested, the result has been that there is not a race to the bottom so much as a ratcheting up. But there are adjustments from the sort of leading programs as well, because they're being competed with by like the SFI. And again, this is the second thing that was on that slide that I skipped by. Policy making and implementation here come in packages or bundles. They're not so sharply distinguished. So these programs are competing on grounds that they have a total package of rules and practices that are better than the other ones. In other words, they come as implementation packages in this somewhat optimistic reading. So, and of course, we have to ask about, I put the governments sort of out on the periphery there, but we can ask about whether there's implicit competition with governments. In other words, are there circumstances in which governments could or would do it better? And certainly there are circumstances where governments decide to take it over, they decide to delegate to these agencies or whatever. they appear to be very dynamic systems. If you look at them on the whole, let's say as systems or emergent regimes. Now, they're often called private and therefore weak and so on, but they are in fact deeply, I'm using the word imbricated with states, deeply entangled. I just don't like the negative aspects of entangled. First of all, for the most part, they promote state regulatory goals. Most of them require compliance with state laws as sort of a baseline. One of the most interesting things that's been happening over the past 3 or 4 years is that states have been having their own management programs certified by these supergovernmental regulatory programs. And many states in the U.S., as well as quite possibly the Forest Service, but up to now, many states have had their programs certified under one program or another. This is true globally. So what's that? In other words, it's an implicit acknowledgement that the standard of social rectitude is that standard. There are many state procurement programs. There's some convergence in these regulatory standards. It's, again, a longer discussion than I can have here. Now, there's also, I say here, some possibility of WTO-mandated adoption. What am I talking about? Well, you know, or you may or may not know, the TBT agreement, for example, provides that if a government adopts a technical standard, and if an international voluntary standard exists in that area, the member states are obligated to use that standard unless it's not applicable for some reason. And you may also know that there is a sort of a feeble act in the U.S., the National Technology Transfer and Something Act, that requires it. How am I doing on time, Phil?
Fine.
Okay. So I'm going to speed up a little bit here. Now, but the reason I put this here is that one can imagine these ostensibly private regulatory systems suddenly going through a transformative moment, and, you know, presto, they're suddenly government regulatory programs. Hence my snide comment about governments being retailers. Okay, now, so I want to talk about 3 things: market chains, competitive policymaking, and institutionalization. I've written a lot about the imbrication issue elsewhere, and this stuff is all on my website, which you can find at SUNY Buffalo Law School if you're interested. But I think that, as I suggested at the beginning, we've under-conceptualized and understudied these phenomena. I'm going to break market regulation into sort of vertical dimensions and horizontal dimensions. So what I showed you with the Home Depot was sort of vertical. That is, environmental activists pound on Home Depot. Home Depot uses its supply chain to eventually buy as many certified products as it can. That creates the demand for certified products. Then what happens is that forestry operations seek certification. So obviously you're only going to be able to pound on Home Depot if Home Depot is vulnerable in some way. So part of the dimension, the strengths and weaknesses of these systems have to do with branding, at least at that level. These things become possible in part because of branding, in part because of massively improved information systems. Today, Home Depot, you buy a wheelbarrow, it has a little barcode on it. They can tell you where the handles of the wheelbarrow were made and when, and by what company. The other thing, again, that I don't have time to develop, but contracting has become the bone and marrow of this process. And so there are law professors, Michael Vandenberg, for example, from Vanderbilt, who's writing about contract as regulation. But this is another implication of these developing programs. Also, buyers don't just say, we'll buy certified products, but they, particularly IKEA, for example, and also some European buyers, sort of go out and create firms that can sell them those products. They help them do that. They consult with them. They create so-called stepwise programs. You're not good enough to get certified now. How about 1/4 of the way this year, to half of the way next year, and so on and so forth. They place a value on good management. So you can see running down the implementation, you can see running up and down market chains, but that doesn't explain industries. And yet, what I've said to you is that the industry as a whole has been significantly influenced. It's not that the whole wood products industry is certified, and it's not that this is a wonderful world where everything is going well, but there's been huge incursion into the requirements for the industry. How does horizontal market penetration happen? I'm treating it as a mysterious fact. Well, there's reputational interdependence in many of these cases. If forestry comes to be seen as dirty, as bad, let's say the way the chemical industry has feared at times, or the way the nuclear industry has feared at times, then you have reputation is a collective good, and the individual, one firm can be damaged by the other firm's harms. They respond perhaps by creating club goods, so that the Forest Stewardship Council becomes a club good. And there were existing industry networks to mobilize. I'm going to very, very quickly finish. Yeah. Here I just want to note that the regulatory spread is also into state regulatory networks, both formal and informal. Let me talk briefly about competition. I've already said some things about it. The competition in terms of implementation is going to be the key. It could be, of course, that I say that the Sustainable Forestry Institute standards are significant and real. It could be a bunch of bullshit. They could just be standards written on paper and nothing's really happening. Unless we have the capacity to monitor that actual implementation, we don't really know whether there's anything functional that we could really call regulation here. My main point is we don't really know. But we do have the capacity to achieve a certain amount of external monitoring because of things like remote sensing and community reporting, which have both become tremendously easier. So that if you've got satellite photos that indicates that riparian zones are devastated, or if you've got photos or whatever, you have the discrediting of the program, and you also have the shadow of the state, possible alternative implementer. I'm only going to say 2 words about institutionalization. And that's because I think legal audiences our dominant model is a logic of consequences. In other words, people do stuff if there are incentives to do it. If there are deterrents against doing it, they won't do it. If there are incentives to do it, they will do it. But these systems can only work if they're broadly institutionalized beyond a logic of consequences. There simply is not enough deterrence capacity in the world to leverage these systems into place. And so there's an argument that in fact, when organizations get in the habit of doing things differently, this becomes taken for granted or institutionalized, and that over time a regulatory regime can come into play almost unnoticed. And that may be happening here, but we don't know. I'll stop here.
Good place. Good. Hey.
What I want to talk about during my time is some of the practical issues we in the Department of Transportation, and by some measures we're the largest regulatory agency in the federal government, some of the practical problems that we have in the issues that come up, and especially with respect to enforcing regulations. When we're talking about collaborative decision-making or regulatory negotiation and other variations of it, from my perspective, it's always good to be able to have an opportunity to sit down with people and to talk to them about the issues that are involved. It can't be a bad idea, and when some people start off by saying right away it's a bad idea, I'm troubled by why there's harm in sitting down and talking. If regulatory negotiation or other forms of collaborative governance are set up in the right way, they have to be helpful. Even if you don't reach consensus, it is a valuable learning process. And those who have participated from both the government and from private parties have told me they've learned from it. The comment about the union member that I made earlier and my comment from the audience about we've learned now how difficult it would be for the government to write a rule that would satisfy everybody. So we are willing to live with something less than we thought we would accept when we walked in the room. They also understand how complex the issues are and how difficult it is to work through the processes in a short amount of time. We make mistakes. We have appointed people to negotiate on behalf of the government who didn't have a good concept of what negotiation was all about. They thought, for example, that it was a glorified public hearing where they were supposed to listen to everybody. As decisions were being made, sometimes they wouldn't say much, and then they would object 2 or 3 days later. This is where the facilitator can be so valuable. This is one of the things you have to keep in mind when you set these kinds of things up. When you talk about issues like balance, the government is the most powerful person at the table. If the government pipes up and says, I don't like this, everybody else stops trying to negotiate because the government seems to have made up its mind. If the government says instead, why are you having a problem with this? What if it were modified in this way? It could be a more valuable negotiation. And we've had the facilitator talk not just to parties, private parties, but also to the government representative at the table and tell them when in the facilitator's mind they are not making good faith efforts to negotiate properly. People have complained and talked about today about the imbalance in the parties. The most powerful party probably in our first negotiation was not participating in good faith, not participating effectively, and went to tell the administrator of the agency that he was unhappy with the way the negotiations were proceeding. The mediator found out about it. He happened to have tremendous independent influence because he came from the Federal Mediation Conciliation Service. I used to say he settled the baseball strike. I now have to say he settled the first baseball strike and got a lot of applause for doing that. It looked like it was intractable. And he went to a party and told us about this later on, and he said, if you ever go outside this room to the administrator again behind my back and talk to him, I will resign from this and I will say the reason I resigned and I will put the blame on you. And he got the message and he sat down, and instead of picking up the newspaper to read it when the union representative would be making a point, he started engaging in good faith. You can set these processes up so they will work. A lot of the arguments against them really go to how well the agency set the process up in the first place. They don't have to take too long. A number of people have talked about that. It's a practical problem. We don't want it to take too long, but more importantly, when we're engaged in regulatory negotiation or some other collaborative technique, we don't want those who are working with us to have to waste time. We don't want them to have to wait a long time to see the results of their action. So we get agreement from senior people that it will move quickly. I disagree with the comment that was made from the audience that you don't want to talk to OMB during the process. We send OMB a letter and we say to them, we are going to engage in a regulatory negotiation. If you have a problem with it, tell us now. If you don't, we'd be glad to brief you. You can attend any of the meetings you want. You can talk to us about where we're going. But when we send it to you, you shouldn't start raising objections. And it has worked quite well. OMB has been very, very supportive. There are times, one time when they thought they knew better than industry, and we said, do you really want it to come out that you thought better than industry about whether this was you knew better than industry about whether this was too costly? They right away said, you're right. And they backed off. So keeping them involved, keeping them apprised is not a bad idea. We haven't seen more litigation. I think a lot of the studies that have been done have limited the rulemakings that they've looked at. Too many people, for example, tend to think EPA is the only one that you need to study to find out how well the process is working. EPA works on very controversial rulemakings. And the fact is they probably also get sued more than other agencies do on all of their rulemaking. So the fact that they might get sued more in negotiated rulemakings may not necessarily indicate a problem. We, I don't believe, have ever been sued. If we were, it was a minor suit many, many years ago. Phil probably remembers better than I do. We also don't think fake is a problem. Yes, it's there. Yes, it requires us to fill out some forms. They're standard forms. The administrative conference even put them in a book and put them out for everybody to see. Just fill in the blank with the substance of what your rulemaking is about and the name of your agency, and you've got yourself a charter, you've got yourself all the other documents. The statistics about the benefits, they're not easily measured. I am not using regulatory negotiation on a regular, everyday rulemaking. So measuring the time it takes to complete a negotiated rulemaking compared to a rulemaking that I do every day of the week is not going to tell you very much. The first one we used it in involved a proposed rule put out by the FAA on flight and duty time limitations. They got attacked by the unions. They had to start all over again. They put out a new proposal a couple of years later. This time they got attacked by the industry. They had to withdraw that one. Congress got involved. Legislation was passed prohibiting the agency proceeding to a final rule, as I recall. All kinds of problems. They then started a negotiated rulemaking. They successfully completed it, issued a rule, did not get challenged. How do you compare that? Do you start with the middle 1970s when they issued the first proposal, or did you start and measure it from when we started the regulatory negotiation? Because the FAA found that they could not work this problem out without negotiated rulemaking. And that's true for a lot of the other things. We use them for very contentious, very difficult issues. We don't use them for things where there's no difficulty resolving the disputes. Probably one of my favorite quotes was from the administrator who said, "I love the concept of negotiated rulemaking. I'm so tired of the opposing parties on the outside coming in to tell me everything that's wrong with my proposal. I'm going to give them a chance to negotiate it now, and if they can't agree, I defy one of them to come back into my office and complain the next time around." Now, this is not to say, and that's why I want to stress that you don't compare this to regular rulemaking. This is not to say that negotiated rulemaking is perfect for lots of rulemakings. It's good for particular kinds of rulemakings, particular kinds of issues. We don't want to use it every day. It does take more of our resources. It does take more of our time, and it takes more of the participants' time. It's not necessarily true that they need to be there for these kinds of things. Written comments and oral testimony at public hearings can be quite valuable. But it is a lot better to be able to sit down in certain rulemakings and have the give and take. It's very, very helpful to us. It's valuable even if there is no consensus. But there are some problems with it. It is costly. We don't get increasing budgets to cover the expenses for things like this. The Phil Harters of the world charge a lot of money for their services if you want to hire them as a facilitator. They're expensive to bring in. That's why you've got to use them for the right kinds of cases, right kinds of situations. So we've been interested in what we can do, other ways we can find to collaborate, to get consensus, or to otherwise get a better feel for what it is that the public would accept that would also be acceptable to us. One of the things we're looking at is internet technology and a lot of other things. And let me go over a few of them. One is just using advisory committees. For example, our Pipeline and Hazardous Materials Safety Administration has a standing set of advisory committees, one for pipelines and one for the hazardous materials side of the agency. They regularly send their rulemakings through these committees for their comment before they put them out for public comment. They have a representative body of people on the advisory committee. They're not necessarily asking them to negotiate the rulemaking, but they're sending it to them to see if they can all agree with it or if there are modifications they should make before they propose it. We've also looked at the idea of addressing and I should also mention we've got two, and I don't know if Jeff Lubbers is still here and whether he counted these in his statistic, but we have two standing committees set up solely for the purpose of negotiating rules. The Aviation Rulemaking Advisory Committee and the Railroad Safety Advisory Committee. They both send, I believe, into the dozens of rulemakings to these committees, FAA even larger numbers than that, for them to look at the problem. It might be a statutory mandate. It might be some accidents that have occurred. It might be something else that the agency has identified. Frequently send these to the committee to see if they're willing to negotiate. The agency's part of the committee committee's usually made up of a very large number of representatives because they don't all have to negotiate on particular rulemakings. For example, the FAA may have members from repair stations. The issue might have to do with flight and duty time limitations for pilots. The repair stations wouldn't be put on the subcommittee, but those who are interested would, and they would attempt to negotiate. Sometimes there's so many of them going on, the agency doesn't even send people to all of them. But if they get something that they can live with, they will proceed with it. These are not necessarily all what we would call negotiated rulemakings under the Negotiated Rulemaking Act. And incidentally, responding to the point made earlier, the Negotiated Rulemaking Act was not necessary in order for agencies to be able to negotiate. It's a recommended set of procedures. It doesn't give any authority. The agencies always have the authority to do this, in my opinion. But we have set these two committees up, and we get a lot of products out of them that we find helpful, either with or without consensus in the eventual final document. We've also looked at making better use of government facilitators, and somebody talked about this earlier, about using those who are already trained in things like ADR techniques. We're trying to see if we can use administrative law judges or some of the people who are being trained to, for example, resolve personnel disputes and things like that, whether they have skills sufficient to help us handle some of our less complex rulemakings that we want to do negotiated rulemaking on. We're trying to use more public meetings, and what I mean by public meetings are not hearings where people come up and testify and then sit back down or don't even stay for the other testimony, but rather meetings where there's more of an interchange among lots of people. For example, before we put out a proposal on alcohol testing, we weren't sure what kind of devices we could require be used because we weren't sure whether they were capable of creating a written record of the test results. So we set up a public meeting, invited the public, but specifically invited all the manufacturers of the devices, had a round table with the manufacturers, and we sat up there and we asked them questions. How easily could you modify it? What would it take? What kind of a record could it give us? And let the audience also ask questions, took the results, and put them into our proposed rule. We try to make more use of reply comment periods. Again, this is a form of collaboration. You can't say something new in the reply comment period. All you can do is address what others have said. A lot easier now that we have electronic dockets for the entire federal government, something, in my opinion, we don't use enough of, including in my own department. We've used internet chat rooms. And in terms of what do you do with records like this, it isn't that difficult. You download it and you put it in the docket. You have a complete record of everything that was said on the chat room during your comment period. We are now about to try using a blog, we're going to probably try some interesting techniques. Again, we don't see the problems with using a blog. There may be some other problems with whether we can afford to use the blog because we may not be able to use a public site. We may have to use a government site to do that. But we want to use a blog, and we want to use it to try and build consensus, not just to have a whole string of comments coming in, but rather to encourage the people to look at what people before you have said, to rate them, and I'll get back to that in a second, but to rate them and maybe join in with them and say, I agree with you except for this. And maybe there'll be some back and forth, and more people will join in as they start to modify what they're saying. And we're looking at how we can set it up in a way to encourage that kind of participation. And we're working with the people who were referred to earlier at the Office of Science and Technology Policy, who are responsible for implementing the President's new directive on openness and transparency. So we're looking at this also because, in my opinion, I'm waiting for them to have a 10-point rating scale, 10 stars the best, no stars the worst, and we might have some cutoff in our preamble, so you didn't even get 2 stars, so we're not even going to respond to your comment. We don't know if we can get away with that, but we're looking into trying that.
Amazon rating.
Yeah. That'll save us a lot of time. We'll have to read through all the blog, but save us a lot of time, we hope.
Sucks, don't buy it.
We're not sure if there's any particular circuit we should try this out in first, but we'll check that out. We also have been looking into the concept of facilitated online discussions, where you get people to actually start to do some negotiation with a facilitator in there, asking you some questions. A reference was made earlier, and I think Professor Bingham's remarks to the National Academy of Public Administration having a website that they've set up where they have facilitators who will go in at night and pose questions in response to what has been said during the day, and then those people who are coming in to comment the next day can start responding to those questions. These are some of the things we've been doing, some of the things we're thinking of doing, all with the idea that especially with internet technology, where everybody can see what others are saying, we might be able to get more consensus. May not be a full consensus, but we'll have ideas that have a lot of support. Better than getting a simple standard form that one organization sent out and said to everybody, sign here. Here you can work together to modify it. Private collaboration, a little bit about what Errol was talking about, can also be very, very valuable. If the affected interests all can agree, sometimes it is a document that we, the government, will then rely on and just simply add it to our rule. It can be a valuable starting point. Agencies will take petitions from the public and publish them for comment, or they will agree with the petition and start it off with a notice of proposed rulemaking. Phil, in his paper that was referred to earlier, the paper that got regulatory negotiations started off, pointed out one example where the railroad administrator, in the early 60s, I think it was, said to the union and management side, if you can agree on a way to solve this particular safety problem, because it affected the workers, then if you can give us consensus, we will publish it as a proposed rule if it meets all our legal situation, all of our legal requirements, and then we'll ask for comment on it. We got a petition from both parties. We liked it. We put it out, and eventually, as I recall, we adopted it as a final rule. So there's no reason these private negotiations can't help us, and no reason they can't come to us through a petition or some other means. There are other areas where they can be very valuable. You have to keep in mind, however, that sometimes we have a statutory mandate to issue a rule. And there's some other reasons I'm going to get back to in a second. You also have to keep in mind that there are other variations of our mandate. We do not regulate parking for people with disabilities. But Congress was upset because the various state governments had different standards for who could get a parking sticker for their window. In fact, even different standards for where you put the sticker. So when you went from one state to another, you didn't know whether your parking permit would be any good. Congress was upset. They said, we're going to require DOT to use negotiated rulemaking to develop a model rule for parking permits. So we got representatives of the states, we got representatives of the community, of organizations representing people with disabilities. The Canadian government even said to us, can we join you? They can't be a voting member of the Federal Advisory Committee, but the committee listened to them because they realized it's good if it can not just be national in the United States, but if you can drive over the border in Canada and use your permit and vice versa, it would be even more valuable. And we negotiated an agreement, put it out. And the opposite of what we're talking about here, the states have all adopted the standards. Now, of course, Congress said if you don't, we may adopt it as statute or make the agency suddenly start regulating in the area. But the states had worked it out. They liked it. They were perfectly happy with it. They had no reason to object to it. There's no reason to have different standards for who needs a parking permit. There are problems, however, with implementation if you've got a purely voluntary standard, even if it was reached through collaborative techniques. For example, the FAA regulates when it regulates aircraft, especially large, complex commercial jets, it oftentimes doesn't want to take that plane out of the sky and make it be grounded to have a fix put on it until it's going to be scheduled to be taken out of service for regular maintenance. Saves a tremendous amount of money, but sometimes that could mean years are added to the process. If we have a voluntary agreement among all the airlines, or the manufacturers in the airlines, that they're going to do something to the aircraft, the next time they take it out of service, and then 5 years later, the airline says, I don't think I agree to that anymore. The FAA first has to start the rulemaking process. Then they first have to put it into effect, and then they have to wait for the next time the plane's going to be grounded for this kind of maintenance. So as a result of that, we have to be a little leery of an agreement that might put a safety problem off for double the time that we might have had to, we would have, given them to comply, because there's no way for us to enforce most of these voluntary standards. There may be some unique situations. There's some other things to keep in mind, and Errol was referring a little bit to a lot of the stuff that's going on internationally. Also think about it at the state level. We have a lot of harmonization efforts going on. State governments get financial assistance from the Federal Motor Carrier Safety Administration, as an example, if they adopt the federal standards applying to motor carriers. They also help us enforce them. We regulate interstate commerce, they're regulating intrastate commerce. And they have more police to put into this than we do. We want them to adopt our standards. They generally want to adopt them. partly to get the money. And so, again, consensus-based standards, having the states involved when you're adopting these things can work in a variety of ways to bring more uniformity. Internationally, with the harmonization, we're trying to work more collaboratively with other governments. The Canadians and the Mexicans and the United States, for example, are talking about joint rulemakings. And again, if we can do the collaboration on a broader scale, it's just easier for the truck that's going to cross the border or for the plane that's going to come in from Europe if we can work these out in a collaborative kind of a way. One of the things we need to think about is how we encourage agencies to make the extra effort to use these kinds of techniques. And I know one of the things that we've been talking to OMB about, many of the agencies have been talking about, is the idea of taking less time. In practice, they've done that with us, but others apparently have had problems. But made a suggestion to OMB that they say that they will complete review within, for example, 30 days if it's a collaborative rule technique that was used to develop the rule. And in practice, our experience has been that shouldn't be that difficult to accomplish. What are some of the implementation and enforcement issues beyond this? Let me stress some of the points that I think are especially important. Representation and willingness to participate, not only with respect to the private participants, but with respect to the government. You've got to be there, and you've got to participate. You've got to participate in good faith. But also important is to remember, especially with respect to private negotiations, is it's a little more difficult if the government doesn't participate in some of these negotiations. The government can effectively represent the public interest, can even represent the interest of those who are at the table in some respects. Take, for example, the flight and duty time limitation that I've used as an example. The airlines may say you've got to fly at least 10 hours without a rest, and overnight, getting off to sleep for 8 hours, because I can't run my airline if I can't get 10 hours out of you. It's going to be too inefficient, and I'm not going to be able to operate and compete. The pilots might say, we can't fly more than 8 hours. It's unsafe. The airline might say, well, what if we raised your salary a little bit? Would you be able to fly 10 hours? That's why you want the government at the table. The government says, wait a second. Now, we also have other public interest groups, but again, in terms of the criticism that they don't always have the resources to understand a more complex variation of this, that's why the government is there. And the government is supposed to be enhancing safety. Our particular interest is looking at the obvious safety statistics. We can't compromise on those kinds of things and hope nobody will ever notice it, because it will be noticed. If it is a safety factor, you'll see difference in the statistics that we get in. Another thing to remember about the use of the government, or at least the notice and comment process that the government has to use, a lot of people say, hey, this slows everything down. Even when you've used collaborative processes, you have to use notice and comment. Well, yes, we do have to use notice and comment, but we have found that it makes it easier for the private parties to participate in the negotiations. The example I gave when I made the comment from the audience about the union, it's easier for them to come and sit in the negotiations knowing that their members will be able to express their views and they will be considered. The union may not even have a full appreciation of exactly what the union members will say or whether they might even like the details of it. You can't go and necessarily get a vote of a large union membership. You might be able to go out to your various chapters. And the same is true of some of the others. They don't necessarily know whether they can, not only whether they can effectively speak for everybody who might be a member of their organization, they're also a little afraid about taking a public position. They're much more comfortable with knowing that they can go back and they can have a comment made on it, and the public can then say whether or not we got it right. Generally speaking, we have found we get very few comments compared to what we have otherwise gotten in the rulemakings, and we get fewer adverse comments. And again, our experience there was with the negotiations on flight and duty time, where they had two rulemakings earlier, and then they used notice and comment rulemaking. The general agency consensus, it's somewhat subjective, is we got comments that were much less adverse than we had gotten in the first two rounds. So again, these are valuable things to keep in mind when you're thinking about some of the things where you think it delays. It actually could be helpful. Shorter comment period, fewer comments, they're less adverse. Some people complain about the political factors. They want to use private negotiations. You never know where the government's going to come out. Well, you never know where the government's going to come out, whether you use private or public. If you use the government process, you're going to get a decision made and you're going to know where you stand. But you might spend a lot of time agreeing in the private world, and the government may not like it, or the government may change political parties, and they may decide they're no longer going to accept it. They're going to write their own rule. Neutrality, objectivity. One of the points was made earlier about whether or not you have neutrality, but no one mentioned the point that sometimes bothers those of us in the government the most. Who's paying for even the facilitator? Even when it's the government, can I be sure if I'm a private party that the government facilitator is going to be objective? They want to get another contract, don't they? They want to facilitate another regulatory negotiation the next time it comes up, don't they? So you've got to be very careful there and keep that into account. And that's something we think about, and that's something we worry about. We had problems, however, and this is something to keep in mind there. There are a number out there who do this on a regular basis, and most of the ones I'm aware of are very, very good reputations. We had real problems, real difficulties with the way the agency rep was handling a negotiation. And we were upset enough, and we had observed some of the negotiations that we had a meeting with him. And he brought the facilitator with him, he thought, to back himself up. And we told him what our concerns were, and he started objecting, and the facilitator said we were right, and he was wrong. He was not handling it well. And he went back and had to learn to do a better job there. Openness and sharing of information. Some concern about using government processes for collaborative techniques because you have to divulge confidential business information. You have to divulge confidential business information in rulemakings in many situations. The government can protect it if it legitimately deserves protection. Corporate average fuel economy standards for automobiles. The manufacturers tell us their future product plans. They tell us what kinds of cars they're going to build in what quantities in the years covered by our rulemaking. They give it to us. We protect it. In private collaboration, I actually had somebody suggest it would be better protected. How can they have collaboration with the competitors? That's whom they're trying to keep it from. They wouldn't be concerned if Mr. Public Citizen saw what cars they were going to build in 2000. They're concerned with whether their competitors see it. So we, again, can do a job there, and that's true with other kinds of information, not only under, in general terms, but under FACA. There are reasons for closing doors so the public cannot attend meetings. There's work that can be done in committees. The vote still has to happen in a public meeting, but can be done in committees that can be closed to the public. Also a question about whether the government can impose punishment if it's not its rules. And again, I mentioned that earlier. The government has to be able to enforce its requirements. We've also found, and others, Jeff talked a little bit about this, we found and feel quite strongly about this, that people are more willing to comply with rules in general, particularly when they feel that they have been invited to a negotiation, but even when they've just had an opportunity to compete in the notice, to participate in the notice and comment process. The fact that they have written a comment and been told why we couldn't accept their point of view still makes them happier than if we had never answered them, never heard from them. If they get invited to participate in meetings, it's even better. It's obviously easier to comply if everybody affected by the rule is represented, helping us draft the actual language. Sure, there are going to be some misunderstandings. The misunderstandings should be a lot fewer. We should be a lot clearer in the rules that we've written. We should have more uniformity because we're getting more people involved in this, and it makes it easier for it to be used throughout the rest of the world. We shouldn't lose sight of the fact, especially when we're talking about voluntary standards, that the rest of the world is oftentimes the smaller countries are looking for standards to adopt for their manufacturers, for example, to meet so they can sell their products anywhere in the world. And if the U.S. government doesn't write standards, they may adopt EU standards. And then our manufacturers are going to have to meet EU standards even though they thought they took care of it with some voluntary standard. So that's another thing to keep in mind. Per se negligence. If you violate a federal regulation, a safety rule, it's per se negligence. You would not necessarily have the same thing be true if you did that through a voluntary process. So in conclusion, I'd like to stress 4 points. I think collaboration is valuable. I think that we need to continue to explore new techniques, not just because we need to find ways to keep expense down, but also because some of these new techniques offer ways to involve more people in some of these processes, perhaps in a more efficient way. Again, the new techniques, we also need to explore other ways to keep the old processes less costly, such as regulatory negotiation. And we need clear support for the rest of the government. We think we've had it in our rulemakings, but obviously some parts of the government don't think they have clear support from OMB, and that's something that we've got to convince OMB that they need to address more strongly. Thank you.
When Phil asked me to be on this panel, he said, displaying the light touch and gentle flattery that makes him so good at as a facilitator, we need someone who will really spin a lot of BS. You're good at that. Right? So I take that as a compliment. Thank you, Phil. No, I remembered it pretty clearly, actually. He also today was careful to say to me, look, just remember you are standing between the audience and their drinks. So I have now this double mandate of BS and brevity. And then he also said that he wanted me to be provocative, and my assigned topic is judicial review, and I'm not sure one can really be all that provocative about judicial review. But I will try, though I'm going to back off in the end from the more provocative things, if that's the right word. Judicial review, of course, is in many ways at the heart of administrative law. If you think about administrative law as being the collection of doctrines about limiting agency discretion and providing various forms of oversight, judicial review is at the heart of that. Not the only kind of oversight, but a fundamental one that the system assumes. And of course, judicial review is to some extent the enemy from the point of view of agencies often, and one of the standard claims for collaborative governance is that it has the advantage from the agency's point of view of getting them out from under judicial review, that if nothing else, it's more likely that a decision will go unchallenged. You won't have to face the courts. And that even if you do, perhaps more likely that it will be upheld. What I want to do is just offer some speculations, pretty tentative speculations, because I guess I should also stress that, I know less about collaborative governance than probably anyone in the room, and certainly than anyone on the table, and it's sort of embarrassing to follow Neil Eisner in that regard. So did I say my thoughts are tentative? Yeah, they're tentative. But some tentative thoughts on whether, in fact, the standards or availability, the scope or availability of judicial review ought to be different when the agency action being challenged is an example of some form of collaborative governance. Now, beginning with one big idea, which is the sort of fundamental debate never to be resolved, though it ebbs and flows, about whether agencies are technocratic experts who are grappling with quasi-scientific challenges that have real right and wrong answers, which was largely the New Deal model, or whether they are just folks with preferences and values subject to political controls and political motivations. Those two models, neither will ever or has ever completely triumphed. But the more you see agencies as technocrats, as experts, the more they should be left to their own devices. Oversight and review can only screw it up, right? And the more that they are, in fact, that there are not right answers to the problems agencies are trying to solve, the more oversight of some sort looks reasonable, and political oversight or influence in particular looks less problematic. And over the last 100 years or so, we have moved more or less with fits and starts and not completely from the first model to the second. And so what you see is fewer independent agencies over the last 40 years, greater presidential control of rulemaking, more emphasis on democratic control. To some extent, judicial review is outside of this dispute, because courts suffer both a democracy deficit and an expertise deficit, right? Whichever is your model of agency action, it's not clear what courts can add. Chevron, the big hands-off decision, thus doesn't have to choose between its two justifications. A, agencies have more expertise. B, agencies are politically accountable. Under either and both of those, better that agencies should make policy decisions than that courts should. So the central justifications for judicial review all involve ensuring the agency is doing its job properly as opposed to doing the agency's job for it, enforcing popular preferences as expressed through statutory constraints, the so-called transmission belt theory of judicial review, ensuring that if really agency expertise is at stake, the agency decision reflects that expertise because it's well-reasoned and carefully thought through, and reviewing procedures, ensuring that the agency followed appropriate or legally required procedures. Now, collaborative governance makes claims under both the expertise and the preference or preference aggregation models, right? In part, the idea is to tap into expertise of the people with the most knowledge, supplementing the imperfect expertise of the agency. But my sense is really the stronger claim about collaborative governance is that it's sort of democratic. You get all the relevant interests around the table and achieve consensus. And the collective judgment is not so much correct. It may or may not be. Indeed, we're not sure there are correct answers. But it is agreed upon. That's its essential feature. So if that's the kind of governmental decision being made, well, we have a model for reviewing such decisions, right? It's not our judicial review of agency action model. It's our judicial review of statutes model, right? That's how we treat statutes. Legislation may be right or it may be wrong. We don't actually ask that question. It is. That's all. And what legitimates it is not the expertise of the legislators. It's their democratic mandate. And similarly, collaborative governance often does not so much implement statutory decisions, which is the traditional agency model. It, to some extent, replaces them. You can think of the much-quoted adage from within EPA about Project XL, right? Everyone's heard it. If it ain't illegal, it ain't XL. And that is, and in that sense, so here's strong proposition number one. Judicial review of collaborative governance ought to be along the same standards as judicial review of legislation. Right? Is it unconstitutional? Is it barely rational enough to not violate the Due Process Clause? And that's it. Right? Because it's sort of, it's the kind of creature it is, looks most like legislation. Now, your willingness to take that strong position, and that's a stronger position than really anyone takes, even Phil Harder. Your willingness to take that depends on your, not so much on your belief or your belief in or confidence in courts, and more in your belief in or confidence in collaborative governance. But if you're a real true believer, it's not clear how much courts can bring to the table. For the skeptic, of course, just the opposite would be true, that judicial review of collaborative governance should be especially strenuous. If you lack confidence in the integrity and legitimacy of the process, if it's one massive giveaway of governmental authority to private interests, if it's a sort of per se violation of the non-delegation doctrine, well, then judicial policing of these decisions ought to be especially stringent. It's all the more important. You need more ferocious judicial review of collaborative governance than of ordinary agency decision-making. What I want to do is just flesh out some of that in thinking about sort of three basic goals or types of judicial review of standard agency action, right? Courts review agencies for the legality of what they've done. Is it consistent with the statute? Is it within the scope of their authority? For its rationality, not arbitrary and capricious, reasoned decision-making, adequately explained, and for procedural regularity. Bearing in mind, I should just say that under current practice, this is not a special species of agency action. Judicial review is entrenched. There's no there are no special rules really for judicial review of agency of collaborative governance. The Negotiated Rulemaking Act says so in so many words, right? No special deference for rules that are the result of this process, though it also says no challenge, procedural challenge, to the process of setting up the committee, and I'll come back to that. I find perplexing exception. And you know, such rules have been challenged. Some aren't, some are. They've generally been upheld. Hard to say that, you know, probably some of them weren't challenged because of the process, but the ones that were challenged, impossible to tell if they were upheld because of their reg-neg pedigree or not. So we're not really talking about what the official regime is. The official regime is this is agency action and the ordinary rules apply, but we're going to think about what it might be and what the possibilities for more relaxed review might be. So, first of all, with regard to substantive rationality and reasoned decision-making, as I said, the strong position is that the court should still review for rationality, but rationality here just means not unconstitutional, right? A completely irrational law is, in theory, unconstitutional. Those are hard to find. Courts are unwilling to do it, but if really it's not rationally related to a conceivable legitimate governmental interest, it's unconstitutional, and such review should exist for any kind of governmental action. No one's arguing that it shouldn't. But like the legislative process, collaborative governance is a kind of deliberative political process that reaches outcomes through compromise and to some extent log rolling. The outcome is likely to be, at least in some respects, incoherent. The ordinary standards of consistency and reason giving don't necessarily apply if you have a process that's about compromise. And there's just going to be some goofiness and some internal inconsistency, and we live with that in statutes, and we would live with that here. One way of thinking about this, the strongest statement is what jurisprudents call pure procedural justice. Okay? So situations where you cannot identify the correct outcome. There's no such thing. It's an incoherent idea, except insofar as the outcome was generated by a particular process. Okay? So the standard example is gambling. Right? If you think of, you know, there's no right result from throwing dice or from spinning a roulette wheel. It's not that, you know, 31 red is right and 27 black is wrong. There's just an outcome, and as long as the dice aren't loaded and the roulette wheel isn't magnetic, there's nothing to say about the result except that's the result. And it's the right result because it came from this process. The idea of a substantive objection is just incoherent. And so the strong view of collaborative governance would be that. Right? We've got a fantastic process here. Whatever process whatever result it produces is the right result because it came from this process. And we just stop there. Now that's completely at odds with, say, a case like State Farm, right? Everyone remembers State Farm. But it kind of resonates a little with some of the debate in State Farm, and maybe collaborative governance is different enough from ordinary agency rulemaking or decision-making to justify it. One of the fights in State Farm was the disagreement between Justice White for the majority and Justice Rehnquist dissenting about the role of politics. Remember, State Farm was the passive restraints rule, which had been, you know, adopted in every Democratic administration and withdrawn in every Republican administration. And then Ronald Reagan becomes president, and the rule is withdrawn again. Justice Rehnquist's dissent emphasizes that this change, the withdrawal, was understandable, reasonable, and therefore legally valid in large measure because Ronald Reagan won the election. That's the answer. He ran on a deregulatory platform. He had a deregulatory mandate. He was doing what he was elected to do. There we stop. He's the president. He can do it. And DOT didn't have to explain that decision. They can just do it. Justice White ignores this completely, right? Just ignores it. and focuses on what was the reason given and was the reason adequate enough, and there's this intensive review of the specifics and whether, in fact, the agency had articulated an adequate justification, which it had not. Whatever you think of State Farm, and who had the better of that argument in State Farm, the Rehnquist position is stronger, relatively speaking, in the collaborative governance setting than it is in the State Farm setting. Election of the president, presidential control over agencies, all that kind of stuff that's at work in State Farm, that may be too dilute and uncertain to justify foregoing reasoned explanation. But hands-on participation of all affected interests in the direct formulation of government policy, that's a much more direct and pure form of popular decision-making. And therefore, the argument would be there's no need for judicial oversight of the rationality of what the agency has done. And therefore, no need for a good explanation of why it's rational, right? So the black-letter rule of State Farm is arbitrary and capricious review is more searching than rationality review under the Constitution, and the proposition here would be that just doesn't apply in the collaborative governance setting. The second aspect of substantive review, I'm actually confused as to whether this is substantive or procedural. Which, you know, we all have been since first-year civil procedure. But it surely is necessary. Well, I don't know. It strikes me as surely necessary that a court be available to consider whether, in fact, in the reg-neg setting, a consensus was achieved, right? The legitimacy, the whole premise is there really was a consensus. And everything I just said assumes the existence of that consensus. If you can't get a court to look at whether there was a consensus, then it seems to me, you know, and as I say, I don't know enough about the real world to know how often one might fake the consensus or someone would agree to a consensus, you know, pretend to agree and not really, and so on and so forth. But there's got to be judicial review for that. But how you do that is a nightmare, I think, because you got to figure out what, you know, how much is consensus, 23 out of 25, 24, 19, I don't know, and then how you prove it, right? It's the Morgan problem in ad law. How do you get into people's heads? If they signed off on it, does that mean there was consensus? Supposing, you know, we heard some of that in the discussion after the first panel. You know, if the person at the table said yes and he represented a trade group, but, you know, 80% of the trade group's members are opposed to it, et cetera, et cetera. I have no idea how you solve that. Okay, that's all about reasoned decision-making. I'm not forgetting about the need for brevity, I promise. Legality. The strong version, again, would be no rule for courts at all, right? This is a kind of lawmaking, and there's nothing to test the outcomes against, right? We shouldn't insist that something be consistent with the statutory mandate. Either it is consistent with the statutory mandate, in which case you don't need a court to say it is, or it's not, in which case, the hypothesis goes, it's an improvement on the statutory mandate, right? Again, think of XL. What was the whole point of XL? Avoiding statutory mandates, right? That is to say, the law was insufficiently flexible, imposing, you know, difficult requirements that we could quietly between, you know, the agency and the regulated entity get out from under. Now, again, that approach is not reflected in the Negotiated Rulemaking Act. It's not reflected in what courts have done. And it's not actually the position that as I say, people like Phil have taken. Phil, in an article, gave the example of log rolling, inappropriate log rolling, where, for example, in an OSHA reg-neg, if the workers traded off safety against higher wages, right, and that would be inappropriate, and a court should not allow that. But I'm not sure why you think that, actually, because this is not Neil's example. It's not Neil's example of paying the pilots more, because there aren't third-party interests at stake. This is a setting where if you really, really believe all the relevant interests are at the table, and they really do agree to this. You know, it's Pareto improving, as an economist would say. There's not really, there's no distributional consequences to worry about. You're not creating an externality for the flying public. Right? Okay. But of course, there is a problem still. There is a problem in the world we have. The problem's called the Constitution. You know, Congress makes laws under the Constitution. It can delegate to some extent, but other actors can only act legislatively to the extent they have a delegation, and part of what permits broad delegations on the standard account is judicial review of the action taken under those delegations. So I think there's really no getting around the need for judicial review of legality in the sense of, you know, consistent with the basic statutory authority. There's a milder position, and it's also one, as Phil has argued for, which I just would mention, which is, yeah, we'll do that review, that kind of substantive review of substantive legality, but we'll kind of have a thumb on the scale. You know, if it's not really, really badly inconsistent with the statute, we can live with it. Here's, you know, this is, as many people here know, there's a fight about the wood stove rule as an example of Bill Funk wrote an article where he said one of the problems with the wood stove rule is that it came up with a rule which is illegal. It's inconsistent with the Clean Air Act. And Phil says, quote, while the rule may not fit comfortably within a narrow reading of the Clean Air Act, it is within the Act's overall theory, and a decision that is reached by a democratic process should be accorded some leeway in that regard. Right? I think we would sort of paraphrase the standard phrase of Scalia and others and just say this is, you know, good enough for non-governmental work. Right? I'm not sure how a judge does that exactly. It's not that illegal. Right? And therefore I uphold it. But it might be possible. Let me give you two models of it. One is, this looks a lot like review of settlements. Okay, and you can think of collaborative governance as a kind of settlement. And the key concern in approving settlements is whether third parties who weren't part of the process are being screwed, but we will also ask, you know, fraud, duress, constitutionality, and in some loose way consistent with the statute. But the reality is judges approve settlements that come up with relief, which is absolutely not obtainable through litigation all the time. And so there may be an analogy there. And the other analogy would be to the idea, the distinction between, well, here's what I have in mind. I heard, oh man, what's his name? Who was the last Solicitor General before Elena Kagan? Thank you. Paul Clement gave a talk where he said, here's the difference between the SG and the OLC. The OLC has to say, this is legal or it's not. The OLC is like a court, like our traditional view of a court, whereas the Solicitor General is a lawyer and represents a client and has to say, you know, can we plausibly take the position that? Right? And that's a very different inquiry. And so one could imagine in judicial review here a court saying not yes or no, on or off, legal or illegal, but more, can one plausibly take the position? If you were a lawyer, would you be sanctioned? Last thing, just quickly, procedure. It seems to me that judicial review of the procedure, compliance with procedures in this setting is actually extremely important because the legitimacy of the outcome, as I said, depends largely on the claim that the procedures were A, appropriate, B, inclusive, and C, followed, right? Again, the key thing just in the reg-neg setting being that all affected interests really are at the table. So the process is set up to maximize the chances that they will all be there. There's a convener, there's lots of notice, there's opportunity for affected interests to come forward. I mean, built into the whole regime is a recognition that this is extremely central. But that becomes an argument for judicial review of those procedures, right? The excluded entity has to be able to go to court, I would have thought, to say, I should have been there. There was a defect in the procedure. You'd have to have a lot of confidence in the incentives for interested people to end up at the table, for the built-in protections. You'd have to have a lot of confidence in those protections to say that sort of review is unnecessary, though, of course, the Negotiated Rulemaking Act does say that sort of review is unnecessary. And I think presumably that reflects an assumption that, you know, in judicial review terms, the reg-neg process is not the real process, right? It's leading up to the proposed rule, and then we have ordinary notice and comment. And in a sense, because reg-neg is ex ante, any errors are harmless errors. So because no process was necessary, we're not going to worry about whether the process was exactly valid, and all defects can be cured through notice and comment rulemaking. I just don't see that, frankly, and I don't. And if you really think, you know, reg-neg is this incredibly valuable process, you shouldn't see it either, right? The point is, it does really set the agency down a particular path, and procedural errors prior to the proposed rule are important for the same reason that the very process was important. So, and the other thing is that in the real world, to some extent, procedural and substantive review are alternatives, right? If you have very strict procedural review, maybe you can back off a little on the substantive, and vice versa. It's a little unclear what procedures, however, would be enforced. We have the Negotiated Rulemaking Act, but we don't have anything for XL. We don't have, you know, Neil mentioned that, you know, the agency is involved in lots of negotiations and discussions that aren't pursuant to a specific statute. Are we really going to have the courts police and supervise those? That gets you into Vermont Yankee land, and the short answer would probably be no. There's nothing to enforce. The last thing I would just mention is the question of incentives, other considerations, right? If you really want to get agencies to pursue negotiated rulemaking, the comment was made earlier this afternoon that it's just not in the agency's interest, eliminate judicial review. Just eliminate it, right? That creates an incentive, right? Then, you know, if an agency knew it it could not be sued, well, that would be a pretty powerful incentive. It would also be an awfully powerful incentive to get people at the table and participate. Right? So if that's really our goal, that's how to do it. On the other hand, if you really have your doubts, then you want to dissuade people from taking this route. One way of doing that is by ensuring judicial review, right? And so the claim has always been made, look, you're less likely to end up in court. So here's my final provocative proposal, and I'll set up. We create the position of public advocate in the federal government with authority to challenge the legality of any negotiated rule. That's the public advocate's job, right? We're going to hire Rena Steinzer for the job, and that way we will ensure full and effective judicial review of all agency action, collaborative or otherwise. Thank you very much.
Provocative, and he didn't stand too long between us and our drinks. I want to confess error just one little bit. I think Michael's right that the provision of the Reg-Neg Act on prohibiting judicial review where it does not work. It's easy to see that now from 20 years later, actually a little more than 20 years later. If you remember back when that was written originally, we were suffering a huge amount of interlocutory appeals from NEPA statements that just stopped everything dead. That's what it was designed to do. It doesn't work. So I confess error. Anyhow, questions for everybody else. Standing in the way, of course, between us and drinks. Dan.
This is for Professor.
Well, you need a... Oh, I'm sorry. Cynthia beat you to a microphone, so you lose, Dan.
I'm Cynthia Drew. That's for Professor Meidinger. I'm really intrigued by your suggestion these regulatory regimes come into play almost unnoticed. And I think you told an interesting story of the forest product certification. I'm wondering if we can profit by that, translate it forward to the climate change. As we were thinking about with the prior panel, there are so many actors, and there is such gridlock, especially after the last administration, such reluctance even to look at it, which we hear among the members. And so We have, on the other hand, this upside-down model of the traditional cooperative federalism where the states have been active on this. We have corporate actors. Even the oil companies, the traditional oil companies, want to be known either for PR in the marketplace or some companies actually taking steps. The Vatican's carbon neutral now. Many of the tourism bureaus of certain countries are saying this. So is the market maybe something that, we can translate your case study into other contexts, maybe more consciously? I'm also thinking of how quickly we got the protection for dolphins, for dolphin-safe tuna. And that's something that has happened kind of serendipitously, but it may be what we have to work with on the climate change front now.
Yeah, I'm not an expert on climate change, but I have been following it a bit, and some of those things are happening. There are private certification schemes for carbon content emerging. There are certification schemes for sequestration and sinks emerging, and what, under Kyoto, what constitutes additionality? There's I think the primary arguments on additionality are happening. I don't know if they're the primary ones, but a lot of the work is being done in the effort to certify particular set-asides or a decision to forego a forest clearing project as additional or not. Whether how much of this regime could be contributed by these sorts of processes, I very much hesitate. I hesitate to say, partly because I'm only sort of a follower of this field. It seems like this is one of those all or nothing things, at least for one with my capacities. But one of the reasons would be just the diversity of interests that you're talking about. The oil-producing countries aren't going to be particularly impressed by a logic of appropriateness, or so that somehow I think the problem of bringing all of the key players in is beyond what can be done by these private schemes. But some of the terms I do think are being hammered out by these private or quasi-private developments, many of which people are just going and doing it. They're investing resources in doing it, betting that it'll work.
Dan?
Just one quick question also for Professor Meidinger. What about the role of supranational government organizations like the World Bank, the IFC, and so on around the world?
Yeah, there is a continuum there. They're all, you can, the supragovernmental or intergovernmental or whatever, IGOs, whatever we want to call them, also they operate in a sort of a similar soft law situation, and I think they're, in some of these fields, very much players. I didn't describe them, but you can see sort of a continuum from those organizations to sort of situations where governments are more involved. Organic agriculture, for example, is sort of a mixed case, to places where governments haven't been much involved, but they have a lot of similar feeling in terms of competitive rulemaking and implementation.
One last? Let me ask one last question. On the Home Depot, did Home Depot adopt those standards before or after Frank Blake became CEO?
I don't know.
Having a senior executive of EPA become the CEO of Home Depot is perhaps relevant to all
When
this.
did he become CEO? I don't think he was the CEO when that happened. What? Well, I was just saying that's the same day. I'm trying to remember what the CEO's name was.
2 years ago, 3 years ago?
Oh, it was well before that.
Well before that?
Yeah.
So it really was market-driven and not eco-driven. Okay. Tomorrow, because... Quickly.
Neil, that was whether in your idea of using the net and blogs or whatever, or facilitated rulemaking responses to guide the questions and get more debate. Have you seen any success in that, either in your agency or this other example? Because Certainly the model out there that you dump all your comments at the last minute and you don't want debate is very strong, especially for those who practice before the net. So I was just wondering how much change you've already seen in that.
I didn't hear the first part of your question or didn't understand it. What are you comparing with a facilitated discussion?
Well, when I practiced law, we would dump comments at the last minute because we didn't want anyone else to see them. And so if you're going to facilitate through a 30-day or 60-day comment period, are you actually seeing progress if people are willing to do that? And maybe it depends on the agency and the trust involved and so forth.
Well, the blog, we haven't tried yet. If we're going to do it, we're probably going to do it in the next 20 days because the particular rulemaking we're thinking about closes early May, and we want to give about 20 days or 30 days to participate. What we've done are chat rooms, and people have participated extensively, even though it was, I believe, in the middle of the comment period. And the FAA did something similar where they had facilitated online discussions, and they said, in fact, I believe the woman who was supposed to be facilitating the discussions was so overwhelmed by the participation that she couldn't keep up with it. So we have had participation in that. Part of this is a demonstration project to help show how we can implement the President's memorandum. And, one of the things the agency's worried about, are they going to get so many comments they won't know what to do with them? But we don't know. We don't know whether it'll track a lot. We recently tried something with a, standard form comment form where we took the headings out of the rulemaking document and put the questions under the headings and everything and hope that the people would use the standard form, where we only got 20 commenters on the rulemaking. So we're going to need some more experience before we have good data, but at least people are willing to start trying some of these things.
The other part of your answer is the reply period.
Yeah, the reply period gets around that completely.
I think there's actually, didn't Tom Brearley write a book that analyzed some of the EPA experience that raised a lot of those, that analyzes a lot of those issues? I mean, it's 5 years old now, but it raises it. Okay, logistics. Tomorrow, since we're down one participant, rather than get up at the crack of dawn and start at 8:30, we'll start at 9. Tomorrow is at 9 o'clock here. Those people who left early, they're just going to have to sit and wait. And so these vaunted drinks that we've been talking about that everybody's standing in the way of is across the street. You go in the main driveway of AU, and there's an old white house up on the right-hand side. That is the president's office. That's where we're going. So it's the only one that looks like a house.
And if you park downstairs, it's probably best just to walk across the street.
You're right.
It's a 3-minute.
Yeah, right. You're in the middle of chaos. Run.